Hello, everyone, and welcome. I'm Kara Bloomberg. I'm the Chief Operating Officer of LandrumHR. Thank you so much for joining us today. We have 45 minutes to answer as many questions as we can related to COVID-19, the legislation that's been enacted, and return to work concerns. Many of our attendees are clients today, but for those of you that aren't familiar with us, LandrumHR is a nationwide human capital services company, and we're celebrating 50 years in business this year. We offer full-service PEO services, worksite management, staffing solutions, executive search, and insurance. Our HRQ division provides human capital consulting, places interim HR talent, and conducts nationwide searches for HR professionals. You can find out more about all of our services by visiting our website, LandrumHR.com and HRQinc.com. Our webinar series aren't all related to COVID. We cover a variety of HR topics. There's a link in our chat feature that will connect you to our next webinar on pay equity analysis. It's scheduled for the 27th at 11 a.m. Central Standard Time. A couple of housekeeping items for the webinar today. You can submit questions using the questions pane on your control panel. We're going to address as many questions as we can during the live Q&A session at the end of the presentation. A link to this recording will be sent to everyone who registered. There are a few handouts in the handout pane that Amie will reference during her presentation today. And there'll be a quick survey that pops up as you leave the webinar, and we'd love your feedback. So I'd like to introduce Amie Remington, General Counsel for LandrumHR. Amie spent the last 15 years of her career at Landrum. Amie has over 20 years in the employment law arena and is a national speaker on employment law topics. Amie, I'll let you take it away.
All right, thanks, Kara. We are going to go right into 2020. This has been a crazy year with a record number of pieces of different federal legislation introduced. I can honestly say in the 20 whatever years that I've been doing employment law, we've never, ever had a year with so much federal legislation that's been so impactful on both employers and employees. And we've done a number of webinars on each of these, but we're going to talk briefly, very briefly in the beginning, just a refresher, so that when we use the words throughout today, everybody will kind of remember which act we're talking to, because again, there have been so many. So the first law that came out was in March, and it was the Families First Coronavirus Response Act, and it had two prongs to it. And the first prong was the Emergency Sick Paid Leave Act. And just by way of refresher, this, the whole FFCRA, both prongs of it, required employers with fewer than 500 employees to provide leave. In this case, the Emergency Sick Paid Leave Act required these employers to provide up to 80 hours of emergency sick leave to all employees, regardless of how long they've been employed, and how much or what kind of leave and what kind of pay they got depended on why they needed the leave. So if somebody was sick, they were entitled to a regular rate of pay, capped at 10 days of pay. And if somebody was taking care of a family member who was sick, they were entitled to the same 10 days, but they got a little bit less. They got 2/3 of their regular rate of pay. But that's the Emergency Sick Paid Leave Act. So it's the first 2 of the 12 weeks of the FFCRA. And then the second of the 12 weeks of the FFCRA was called the Expanded FMLA. And it required these same employers to provide up to 10 weeks of job-protected leave when an employee was unable to work or telework because they needed leave to care for a child who's less than 18 years old, because basically that child's school is closed or the child care provider is unavailable. And this amount was capped as well. It was capped at 2/3 of the rate of pay, and it was capped at $200 a day. But under all portions of the FFCRA, both the emergency sick paid leave and the expanded FMLA, one of the themes that we talked about throughout that remains consistent is that job restoration is guaranteed, and there are very strong no retaliation language in those laws. So as we go forward today and we talk about the expanded FMLA and the emergency sick paid leave, just as a reminder, those are the provisions that we're talking about. And then right on the tails of that came a 4-phased CARES Act, which was the Coronavirus Aid, Relief, and Economic Security Act. And in total, all the different phases, it provided over $2 trillion to direct payments to taxpayers, expansion of unemployment benefits, and then for many, many, many businesses, the Paycheck Protection Program, the PPP. It was emergency assistance for healthcare response and for businesses that were impacted by COVID. And as we talked about in prior webinars, the Small Business Administration was the administrator of the PPP program, and in total, it authorized up to almost $350 billion of federally guaranteed loans, which were largely forgivable to small businesses. So that when we talk about the CARES Act, PPP is really the primary thing that we're talking about today. And then most recently, as if those weren't enough, there was an executive memorandum that was just issued in the past week and a half, maybe. And the executive memorandum allowed for the deferral of employment taxes for certain employees. So this is brand new information. And the first thing I want to tell everybody is that we are awaiting guidance from Treasury. And if the prior FFCRA and the CARES Act is any indicator, there will be guidances, they will evolve, we'll get input from Treasury, input from the IRS. So I can't tell you everything about the executive memorandum except for what it says right now, but I think everybody needs to bear in mind that, like the other laws, it will be an evolutionary process, and we'll keep all of our clients as up to date as possible. But here's what we know today. So this memorandum becomes final on September 1 of this year, unless, of course, there are changes between now and then. But as of right now, it becomes final on September 1. This memorandum applies to the 6.2% of Social Security taxes on employees who earn less than $104,000 annually. It does not apply to the employer's portion. And by that, I mean it does not apply to the employer's obligation to pay their 6.2% or to the 1.45% of Medicare insurance taxes. And when you look at who makes $104,000, the way it's calculated right now is you ask, if I paid somebody on a 26-week pay period a year, would they make less than $4,000 pre-tax per pay period? And if the answer is yes, then they would qualify for this. And what they would qualify to do specifically is the employee would qualify for delaying their Social Security tax payment. Right now, it's not forgivable, but we did hear this morning that there may be some talk about not a delay in these taxes, but an actual forgiveness of this portion of their taxes. But right now, it's scheduled to be a delay for employees of their 6.2%, which means that on April 15th, it would be assessed against their regular taxes. So they would ultimately end up paying it, but it's just delayed to a later date. And there's no penalties for employees who choose to delay these taxes. So there's no interest or penalties or anything like that. Now, on the 12th of this month, Secretary Mnuchin said that the payroll tax deferral was optional for employers. So we definitely need to watch and see what happens with this as this evolves.
Thanks, Amie. Great information.
Do we have a poll question?
Yeah, great information to get us started here with our questions. And just a reminder about what a tremendous amount of legislation that has been enacted and has come down and incredibly confusing for employers. So thanks for that brief review. And we'll jump right in. And I think our first question is going to be around telework, which we know remote work and telework is everywhere. It's in the news. Everyone's talking about it as an employer. If you're attending and a decision maker, you're probably trying to make some decisions around how your business will or won't utilize teleworkers. So we're going to start with a poll from our attendees and would love for you to just take a minute and respond if you can. And the question is, if your employees are currently working remotely, do you anticipate One, staying 100% remote indefinitely. Second would be return to the office within the next 3 months. And third, return to the office, but it'll be longer than 3 months before we're back. So collecting some responses now. Love to have some participation. It's getting a big variety of answers, which I think we expected here, but give it just another 30 seconds or so to close it out. All right. So here's the results. Really a small percentage, 11%, saying that they'll stay 100% remote indefinitely, but just incredibly impactful too to think about. And we don't know what size those employers are that are responding, but a significant amount of employees that are going to totally remote work that may have come in an office every day. 56% returning to the office within the next 3 months. And then, wow, 33% going back to the office eventually, but planning for it to be longer than 3 months. Amie, how does that jive with what you've been hearing from employers?
Well, I've heard employers who have decided to vacate their commercial property entirely. And I think that this is going to be, the telework landscape is going to be a whole new landscape. I hate the word the new normal, but I think it might be what will be the wave of the future.
So, we had a lot of our clients that had to make a really quick decision around teleworking, and, even ourselves at LandrumHR, we're talking about the possibilities of how we were going to phase in telework, and then, in a couple of days' time, made a decision to just all go all in with teleworking. So now that we have some time under our belt, now that employers are starting to think more long-term about teleworking and remote work, tell us a little bit more about what teleworking actually means under this new law.
So, when Congress passed the FFCRA in March, Congress anticipated that many employers would ask their employees to work from home for an indefinite period of time for the purpose of protecting employees from potential exposure and to slow the spread of COVID. Because, of course, if we're working at home alone, the potential for exposure is much, much less than if we're sitting around a large conference room table. And gosh, I wish the person in me had known about Zoom and invested in Zoom back in December, right? I think that would be true for everybody, because these new platforms have really, really made it possible for people to work from home and remain completely connected. But what's surprising to me is that the indefinite period of working from home has been prolonged, and many employers are still having their employees work from home. And some employers have decided that their employees are more productive at home, safer from exposure. And if that's the case, and they can do it, they're going to delay opening their offices indefinitely. I think it's a wise decision. I wonder what it will do to commercial real estate in the long term. I think that's something that we'll see in the next year or 2 years. But I do think the idea of telework is still a fairly new concept to a lot of employers and employees. And I think one of the keys to a good remote work relationship is a very clear understanding on expectations. And I love a good policy. I love writing a good policy. And so I think a policy setting forth expectations is crucial.
Thanks, Amie. I think your slides there aren't moving forward. There we go. Okay. All right. So let's talk about the elements of what you would include in a good telework policy.
So I think a good telework policy should first say who is eligible for remote work, because certainly some jobs would not qualify for remote work. If you have a company and you install things in other people's homes, you can't do that work remotely. But if you have a data processing center, or you have people who work on their computers 90% of the time, many of those jobs can be remote. Jobs that agreement or some information to let people know how to request working remotely if they've not already been asked to do so. And there should be definitely a very clear understanding about communications and electronic systems. So, for example, technology-specific issues like confidentiality of passwords, location of computers, whether printing will be allowed at home, and if so, what happens to the things that are printed out. And this is particularly true if you're in a healthcare business, a banking or credit union business, if you're a legal office, if you're in the insurance business, anything where employees have information that's protected by other laws other than general privacy laws, but employees have information to other laws like, for example, HIPAA or Stark or anything else. So the agreement needs to be very, very specific as to an agreement to protect that information. And then I think timekeeping is very, very important, because it's possible that your non-exempt employees who work from home will have unfettered access to their emails 24/7. And if they're like me, every time they walk by their computer, they're tempted to, oh, I'll just click on my keyboard and check my, I know it's before hours, but it won't take me 2 seconds. I'll just check on my email. And for those non-exempt employees, you've got to be sure you're paying people for their time. So there needs to be a clear expectation of, particularly for non-exempt employees, when you expect them to work and what the consequence is if they work outside of those hours. Because first you have to pay them for that time, but then second, you have to set those parameters and come up with a consequence. And if the consequence is that we'll just pay you whatever overtime you work, that's great. But if you don't, if you want to control your overtime a little more, then you need to be able to control the access and kind of monitor the access to make sure that people are being paid for everything that they work and not doing anything that they're not being paid for doing. And then finally, I think it's important to have a clear expectation on what somebody's workspace will look like, again, to prevent the sharing of confidential information. And even things like, and I know our risk management department would agree with me on this, to make sure you don't have hazardous things like cords that are in the way that could cause trip and falls, or, a surge protector with 87 different things plugged in there that could be a fire hazard. We want to keep a workspace safe at home, just as you would keep your workspace safe at the office.
Thanks, Amie. Really great points. And, we hear that a lot about employers that have remote workers that are not exempt at home. And, that's thinking those employees have the best of intentions, right? They just want to do their job and they want to check email, before they go to bed at night or when they wake up in the morning. And the challenge is really that onus is on the employer to monitor that and to make sure that the person's being appropriately paid for their hours.
Yeah, and if you've ever, if you've gotten on a Zoom call with 25 people and you look at some backgrounds, you see there are a lot of people who are working in set-aside offices in their home, but it's very clear that a lot of people are working in their kitchens or in a guest bedroom or, maybe in a shared space. And so those confidentiality concerns are very real. And again, the temptation just to walk by and say, hey, I'll just check this email real fast. I'll just return this email real fast. Those are great, conscientious employees. And you want to motivate those people, but by the same token, you have to pay them if that's what they're doing and they're non-exempt.
Right. So how much freedom does an employer have with deciding who can telework? We just get that kind of question in some form from our clients, I think, every day since COVID happened, of trying to make that decision about who can and cannot and what that means. So tell us a little bit more about that.
Yeah, so one of the questions we've gotten is, I would like employee A to telework and I would like employee B to report to the office so that I can keep an eye on employee B. And I would be very, very careful about allowing only some employees to telework unless you can state the legitimate, non-discriminatory, objective reason, like this person's an installer, so must go out, but this person can telework because the job is a fit for that. Not the person, but the job is a fit for that. So, if, for example, say you had employee A and employee B, and both are data input personnel, but you want employee A to be able to telework because she's reliable and independent and maybe a quiet source who really thrives on a quiet environment. But employee B is a little slower, maybe needs more training, more assistance. But if they're doing the same jobs, it probably doesn't suffice to say, well, employee A is just a better employee than employee B. So I'm going to allow employee A to do this, but not employee B, because that's going to create the impression of a discriminatory treatment. And you've got to be very, very careful about that. So I would be very careful before I started saying that two employees who are in the same job can't telework. But if you can document that employee B needs more training, has a history of not showing up on time, makes more errors, or things like that, then you're a little bit better off. So I'm not saying you can't do it. I'm just saying you have to be careful and you have to make sure you're doing it in a non-discriminatory manner.
Amie, so many of these questions and these topics are related to the trust that an employer and employee have to establish with each other that maybe, wasn't necessarily needing to be there before when everyone just came into the office every day. So I know you always speak a lot about how important communication is with dealing with employees, and especially being able to mitigate what could become a potential large issue for an employer with just good open communication. So we'll launch into the next question here that I think has some trust issues around it. And it seems like the FFCRA legislation came out a long time ago. But with schools starting back around the country, I think we're anticipating another wave of requests. And tell us a little bit more about how an employer is going to decipher what could be a legitimate leave request from an illegitimate one.
So it's a super difficult analysis. I know many people who have worked and teleworked through this whole pandemic at home with children or people, elderly people they're caring for, or just lots going on in their household. And they've done an amazing job of balancing being a full-time employee, a full-time parent, and bringing even a full-time teacher. And then I'm aware of circumstances where other people have requested leave, 12 weeks of leave under the FFCRA, even though they arguably have fewer responsibilities at home. And so it's an employer's, we're humans, and so an employer can kind of scratch their head a little and say, well, gosh, if Kara can do it with all these children at home and an elderly parent she's caring for, and I know she's super busy, blah, 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 and her husband's on deployment, whatever, and Amie has a lot less responsibilities at home, why can Kara do it, but Amie needs FFCRA leave? And so as humans, we kind of ask that question. But my best advice to you is that as an employer, you have to take the word of your employees. You have to treat every request as if you're going to be audited by the IRS. Your employees really, under every other employment law, they have no obligation to provide you a whole lot of explanation of what their personal situation is. They do have to provide you with the information that is in the Department of Labor's questionnaire. It's a questionnaire, the number is number 16. So they have to provide you with that, and I'll tell you what those are. But it could be that the employee who presumably who appears to have fewer responsibility needs the leave because they don't have a spouse or partner to help, because their spouse or partner is deployed, because they're a single parent, maybe they have a child with special needs that you're not aware of, or maybe their kids just simply aren't as independent as other people, other children, or they're caring for somebody that you're not aware they're caring for. So I think this is a time when we have to trust our employees to do the very best. And the other question and answer from the Department of Labor that would be relevant here is number 94. And that one specifically says, we can't punish an employee for taking leave. And as an employer, I know that I would not want to get into the legitimacy of questioning the legitimacy of one request over another request. So I wouldn't want to have to weigh employee A against employee B. Because the very fact is, if you deny the leave to somebody who's otherwise entitled to it, and they decide to bring a lawsuit, it would be a federal lawsuit in federal court because it is a federal law. And they could also sue you for other causes of action, either in federal law or in state law, like marital status discrimination or familial discrimination, sex discrimination, all sorts of things. So I do think this is a time when we have to trust our employees to provide accurate and legitimate information.
Amie, I think you're cutting out a bit on, so I don't know, you may have I know it's kind of storming at my house, so just to let you know if you get closer to the phone there. But I think what we wanted to jump into next is the actual process. So, and what you said was really important. There are all other employment laws. Employees don't have obligation. In fact, it's protecting them from having to disclose things to their employer. And so this has created some complexity for employers that are used to not asking or requiring employees to tell them anything really about their personal life. And there is some information that's required as an employee requests the FFCRA leave. So can you tell us a little bit more about that?
So yes, and we actually have provided a form at this webinar on the pane at the bottom that you can pull down, so that if somebody asks for leave under the FFCRA, we've created a form for you so you can get the information that you need without gathering more information that would create the appearance of an invasion of privacy or any kind of discrimination. In that question and answer from the Department of Labor, it's about 100 question answers long now, but number 16 says, employees do have the responsibility to provide their employer, either orally or in writing, and I'd always recommend getting it in writing, their name, the dates they need leave, the reason for the leave, and a statement that they're unable to work or telework because of that reason. So if the reason for the leave request is because they're subject to a quarantine order, they also have to provide you with the name of the government entity that issued the order. Now, if you're, for example, I'll just use the city of Pensacola. The city of Pensacola has a mask order, and so if you know that there's a government entity that's issued an order and it's relevant to a need for leave, or like the state of Florida, when the state of Florida said all dentist offices must shut down and all bars must shut down. If you're aware that this exists, I wouldn't force the employee to go out and find it, to find the executive order or the municipal order. It's probably easier for you to find, and it's going to apply to many of the employees in that area. So I wouldn't, hold back a request because they can't find the language in the right order. But if the request to leave is because they want to self-quarantine because of a healthcare provider, they do have to give you the name of that healthcare provider. But like much of the FMLA, it's very hard for you to question, well, this healthcare provider, is it legitimate or not legitimate? That's a difficult thing under the best of circumstances with the regular FMLA. But if the reason for leave is because childcare or a school is closed, then they have to give you the name of that childcare center or school that is closed. And again, the best advice I can give is you don't need to create the wheel. We've already created it for you. Just download the form that we've provided and use that. That might make your life a little easier. So Carrie, did we have another poll question?
Yeah, so school is opening across the country in a variety of ways, brick and mortar, virtual, combinations of both. So just getting a ton of questions around how employees are going to deal with potential setbacks with COVID if the school's closed. I thought we'd just stop a moment and launch into one more poll question here around if your business has developed a contingency plan to address possible COVID-19 related disruptions during the school year. I wanted to just get a feel from our attendees if that's something that everyone's addressing or thinking about as the kids start back to school. We'll wait just a couple of seconds here. All right. So 67% no, 33% yes. Amie, how does that align with what you're hearing employers asking around school contingency plans and leave requests?
Yeah, so I think the challenge for parents here is hard to overstate. We've talked about in prior webinars that employees are a bit overwhelmed, and especially, as I said, for somebody who's a full-time parent and now a full-time teacher, if they've got virtual school and also trying to be a great employee, it can be overwhelming. So now we have to throw into the mix what happens if your child is going to virtual school this year. And luckily for us, the Department of Labor has provided a guidance question on that. Specific to that, it's question number 70. And it says that whether somebody is entitled to FFCRA leave depends on whether the school is virtual or in person. So if you have an employee whose school has gone entirely to a virtual platform, there is no in-person offering, then they can take time off under the FFCRA. But if it's a choice, if you've got a choice between traditional instruction or virtual instruction, the fact that you have chosen traditional instruction does not mean, or virtual instruction does not mean you're protected by the FFCRA leave. So I think that's super interesting that it depends on whether traditional is an available option, even if you do choose virtual. What is not addressed, but I think will be the reality question, is what about parents who select traditional school and then they send their children to school and say, for example, a teacher gets sick and that entire teacher's class goes home for 2 weeks? The question doesn't answer this directly, but I would think that the FFCRA leave would then provide leave to parents who are, because they're now unable to work or telework because their school has at least temporarily closed, or because the classroom is closed. But that is something that we're just going to have to wait and see how this evolves.
Thanks, Amie. So, you know, one of the things that we've talked about, I think, consistently during our webinar series is how important consistency is and consistent policy, and certainly around returning to work and the parameters on how an employee returns to work, and questions about testing. So this particular question on requiring proof of a negative test result, how important is that for an employer to make that decision across the board? What does that look like? Just tell us a little bit more about creating those policies.
So it is, the question that our clients have asked many times is, can I require proof of a negative test? And the answer is yes, you can. The Department of Labor answered that in question number 94 and said that's perfectly okay that you require proof of a negative test before allowing somebody to return to work after they take FFCRA leave. Now, of course, it cannot be just applied in a discriminatory manner. So an employer cannot say, well, all men must provide results, but women don't have to, or even worse than that is, you know, all persons of a certain age must provide negative test results, but persons of a younger age don't have to. It does have to be done consistently. But one challenge that I would raise is that COVID tests can often take a long time to receive. I know, just by way of personal example, I took a COVID test and got my result in 18 days, and my child took a COVID test and didn't receive the results for, I got my result in 18 hours. My child didn't get her results for 18 days, and both results were positive. So it wasn't like it was a difference with positive and negative. It was just a test. I can't explain the difference, but 18 hours versus 18 days for a positive test result. And so, it can be challenging for an employer because they don't want their employees out for 18 days if the test result were negative. Another challenge is that there could be false negatives. Perhaps the specimen wasn't sufficient enough, or maybe the virus hadn't manifested itself in somebody's body to the extent where it could be detected. And then lastly, and here's the really important thing, just because somebody tests negative on a Tuesday doesn't mean that they're not exposed and will test positive on Wednesday. So I think the better option for employers is to rely on the CDC's website, which is really, really robust, by the way, and make sure that they understand the most recent guidance on return to work in their particular industry. I think that's a much better plan than trying to do an across-the-board proof of a test result.
Amie, we're starting to hear some buzz about class action lawsuits, and employers are concerned about the company's risk when what happens if an employee tests positive and becomes ill? How does that relate to my liability?
Yeah, that's a very, very real and timely issue. And I took one moment and I just Googled the words COVID, lawsuit, and employer, and I got a ton of hits on employers who have been sued for negligence related to COVID-19 exposure. For example, a few months ago, we discussed a federal case in Illinois where a Walmart employee had passed away from coronavirus, and his family sued Walmart outside of tort, outside of workers' compensation, alleging gross negligence. They specifically alleged that Walmart, that particular Walmart, did not protect its employees, did not provide PPE, did not enforce social distancing guidelines, and did not properly sanitize their store. And they say as a result of those inactions, their family member passed away. And then there was another, that was a one-off for a while, but a more recent federal lawsuit involved Smithfield Foods, who, if you've gone to the grocery store in the poultry section, you'll see them. And those employees alleged that they were forced to work without adequate PPE, that they had to work shoulder to shoulder without opportunities to wash their hands, so close distance without opportunities to clean their hands, that they were discouraged from taking sick leave. And this is the part that blew my mind the most, that they were actually given bonuses for working while they were sick. And so the employees asked not only for permission to sue in tort, but for the plant to be declared a public nuisance and for the employer to be forced to change its policies. So they asked for some specific performance. So in response, some states have taken steps to help employers limit their exposure. So for example, Mississippi just passed a Back to Business Liability Act, and I won't tell you the whole name of the act because it's very, very long, but it says that businesses who make good faith efforts to follow health guidelines, in other words, if they make good faith attempts to follow OSHA and CDC and any Mississippi state regulations, that they'd be immune from tort liability, which means they can't be sued for negligence. There's an exception for gross negligence, but they can't be sued for general negligence, that if something happens, it would be covered by comp, workers' comp. In Louisiana, just this month, the Louisiana governor signed Act 336, which limits liability for injuries related to COVID-19 unless the employee can show that the employer failed to comply with the applicable state and federal and local procedures. So in other words, if they're following the CDC and OSHA and any Louisiana law, and they're not grossly negligent or acting with reckless misconduct, they're going to be immune. And in Georgia, the governor just signed probably the broadest one. It was the Pandemic Business Safety Act, which protects businesses from lawsuits from any person, not just an employee, but any person who enters a business premises. And what it says is there's a rebuttable presumption that the person assumed the risk of COVID by entering the business. So if I go to a grocery store in Georgia, I assume the risk that I could be exposed to COVID just by entering that business. So the best thing an employer can do, because what's the takeaway here? That's the most important part, right? In addition to knowing what your state laws are, the best thing you can do to limit your exposure under workers' comp or under a broader tort theory is to really, again, take a deep dive into the CDC's regulations and make sure that you're complying with all those regulations regarding hand washing, safety, postings in the workplace, reminders to employees in the workplace, spacing people out, PPE, cleaning solutions, and things like that. If there's an opportunity for somebody to work from home or an isolated area, those are great. And we've provided with today's webinar, the CDC's reopening guidelines. And I think that's a really helpful place to start in terms of how to safely reopen a business.
And you mentioned hand washing there. So what about the office responsibility, the employer's responsibility? Are they required to have the office professionally cleaned?
So the CDC's guideline says that you do not have to have the office professionally cleaned, but you do have to follow cleaning standards. So if you but I will tell you this, I think if I were defending an employer and they had a professional cleaner, I definitely think that gives them a layer of insulation that they would not have if they were doing the cleaning themselves. So if it's in your budget and you can afford it, I think a professional cleaning service is a great investment right now. It'll reduce the potential for liability towards exposure, and I think that's a good thing. Now, if you're a small employer and you have a small space, it may not be necessary. The CDC guidance is really great in terms of cleaning and disinfecting public spaces, workplaces, businesses, schools, and homes. And it has specific steps that you need to follow, such as determining what areas need to be cleaned and how they need to be disinfected, what equipment needs to be disinfected, whether you need to disinfect on a weekly, a daily, or even more frequent business, depending on your organization. And it provides, the guidance, in my opinion, provides the why. Why are some of these answers the answers that they are? And they say, for example, that if you can use an outdoor space, like sending children in school outside to eat lunch, or if you a restaurant using that outdoor space, because the virus dies naturally in hours in an outdoor environment and are killed quicker by warmer weather and sunlight, if you can operate outdoors, you're reducing exposure. So it gives a great why. And then the guidance also asks you to look at how frequently areas are occupied and how frequently the surfaces are touched. So like hard or non-porous material like glass and plastic should be cleaned on a regular basis. But porous areas like carpet and rugs and fabrics, maybe they can be removed. If they're throw rugs or area rugs, they could be removed in high traffic areas. And then also you may want to consider shutting down high traffic areas like conference rooms or break rooms, or even using those in a more staggered manner so you don't have 27 people eating lunch in a very small break room together. And then finally, there is also a separate CDC guidance for reopening a building after a prolonged shutdown. So, or reduced operation. It really talks more about mold than the coronavirus, but it's still a great idea for anybody whose building has been closed down for a length of time.
All right, we're seeing various requirements about masks across state and local governments and employers. I think some of them are really struggling with what the rules should be around masks. And I know we've got a lot of individualized questions from our own clients about masks in the workplace. Amie, what's your advice?
Okay, so the first thing we have to ask with respect to an employee who doesn't want to wear a mask is, does this employee have a disability? And is not wearing a mask a reasonable accommodation? So if you're in a municipality that requires a mask, then not wearing a mask would not be a reasonable accommodation. But working from home or working in an isolated area, those may be reasonable accommodations. And I'll tell you, Kara, we have not had one situation where we've not been able to find a face covering that has worked for an employee. And I mean across the board with all the clients who have asked us questions. OSHA says, for example, that medical masks do not compromise oxygen or carbon dioxide or anything like that. And OSHA has said if employees are uncomfortable, they could use face shields. The CDC says Face shields are also good, but we recommend masks. But this is where you have to drill down to your local law, because some states like Washington say face shields are not an acceptable alternative. So I would, if we're talking about a disability, I would definitely engage in the interactive process, find out if there is a mask that would work for somebody. It may be a higher cost mask than just a less expensive one. But I definitely think this is a great time to work with an employee. And like I said, we have not seen a situation where we've not been successful in helping an employee comply with the rules on face masks.
Great, Amie. And, you know, this is another question that we're getting pretty frequently from our clients that, you know, are hearing their employees are taking a vacation or going on a cruise or going out to a restaurant and wanting to know what's the employer's right as far as regulating what employees do or don't do during non-working time?
So yeah, you can't regulate what the employee is doing during non-work time, but you can tell employees that if they choose to travel to hot zones, that they won't be permitted back in the office for a certain period of time. Or like we said, you can require a negative test result. Those are some things you can do. But generally, just because you know somebody happens to go out in the evening or go out to eat or do things that you're not comfortable with, you can't regulate their non-work time. Unless you're willing to pay them for that time. That would be different.
Well, fortunately, we have started to hear from our clients that did experience initial slowdown. A lot of them are starting to rebound and making plans for moving forward and future growth. And some of them had to make some tough decisions, though, and possibly do a layoff during the time when COVID first hit. So what are the requirements around laid off employees as an employer is looking to hire again, especially where the employer doesn't want to hire or rehire one of the laid off employees?
Yes. So, my first question would be, why was that person still employed at the time of the layoff? If you don't have a great employee, they probably will be more successful with a different employer, and you might find a better employee to take that job. So, but if you're going to bring people back, you need to be able to provide, again, going back to consistency, your legitimate objective basis for selecting one person and not the other. Because if you do it on a haphazard basis or without some objective evidence as to why you selected A and not B, then it's going to look like there's maybe favoritism or discrimination or something like that. But once your employees are back, this is a great time to use your best HR practices to manage your employees, and your Landrum HR professional can help you with that on a daily basis.
All right, so this one gets us sticky because we've had a number of our employer clients that say, hey, my employee hasn't told me that they've been exposed, but I heard that they have a family member, or another employee told me that they have a family member. So what's the employer's right of prohibiting employees from returning if they believe they have been exposed? So I think believe there being not necessarily told from the employee.
Well, again, this is like a whole new world, because we as an employer can't ask too many questions about somebody's personal life, and to ask somebody whether they've been exposed or not is essentially asking a medical question. So if somebody chooses not to tell you, you're really limited in the information you can get. But what the Department of Labor and the Q&As reminds us more than once, as a matter of fact, it says you can't retaliate against somebody for taking leave or needing leave or anything like that. So we have to be very, very cautious about asking people for personal medical information that they have not volunteered.
All right, we are at the end of the most common questions we've been hearing out there, and that was great, Amie, and we've had a ton of live questions come in. So we'll take a couple of minutes here, and I'm just going to throw some questions that have come in to you from the webinar since we started. So the first would be, what's the end date for FFCRA? So the leave what's the end date?
The end date is 12/31 of this year.
Great. And a little bit more on the leave. Are employers required to give more than one 12-week series of leave?
No, they're not. It's capped at 12 weeks. The 80 hours is capped at 80 hours. The 10 weeks is capped at 10 weeks. So it's not like somebody could take 6 80-hour segments. You get one segment of 80 hours and one segment of 10 weeks, capped total.
Great. And you touched a little bit on this on requiring a negative test, but I had a question about what about if an employer requires a negative test or medical clearance from a doctor to return to a job, just like they may do with some other illnesses?
Well, the question would depend, or the answer would depend on whether they're doing that for every single employee or whether they're doing that selectively. Because again, we cannot take inconsistent actions based on sex, color, race, religion, or any other type of protected status.
And Amie, some questions around, actually a number of questions around travel. So how are people establishing policies on employees traveling? So I think let's talk about professional travel for work. What are you hearing about those kinds of policies?
Well, gosh, I miss my professional travel. I love when we go places and do things with our colleagues. And that's one thing I have missed so much about coronavirus. We have not reestablished that yet, but I do think that's a cautious thing to do. Before I resumed business travel, I would want to look at the CDC's website, because the CDC divides personal and professional travel among airplane travel, bus travel, even RV travel. It talks about the highest risk and the lowest risk ways to travel. So if an employer is going to establish business travel, and there's an option to drive a singular car versus be on an airplane, I would definitely choose the least risky, even though it might not be the most efficient. But I would look at the CDC's website on a regular basis and then determine what works for your industry and your employees and what kind of travel they need.
Yeah, I think a lot of employers are trying to work through that equation of when they're going to ask employees to travel again and what those reasons are going to be. And I think employers are really evaluating that part of the equation too.
And part of the answer, I think, depends on, is it traveling so that Amie can go meet Kara face to face, or is it traveling so that Amie and Kara can go to a conference with 1,000 other people? So I think even within determining how you're going to get there, you have to look at the reason for the travel, and does the reason for the travel create a high risk or not?
So Amie, I'll throw you a last question that I think is pretty complex, but what are your thoughts on requiring flu shots or when the COVID vaccine is available, requiring an employee to take the COVID vaccine?
Gosh, if you're in healthcare, there's a whole separate set of rules about what you can require and what you can't before somebody comes on the job. But if you're a private sector employer, I would have to do the research, but I do not think there is any provision in the law that says that you can require a private sector employer to take certain vaccinations. I would have to research that, but I really would be very, very cautious about that. And a lot of people will probably be hesitant to, some people might line up to be the first ones to take that coronavirus vaccine, but a lot of employees may be hesitant and may not want to be the first in line. And I think we have to respect that. But unless you're in healthcare, you need to be very careful before you require people to do something that is not job related.
Yeah, well, I think what we can see from today and see from the questions that we've been receiving, we're definitely not at the end of our COVID-related webinars. Much more to come as we go along here. So, Amie, thanks so much for all of the information today. Thanks for everyone for attending. Everyone who registered will be receiving a recording of this webinar. Just a reminder that there'll be a quick survey that's going to pop up as we leave today, and please take a minute to complete it. Let us know if there are some additional topics that you would like to see us bring into our webinar series. On behalf of LandrumHR, appreciate your time. Have a great day.